So now let's talk about the RFEs, and we'll break it down a little bit for you. We'll take real life examples. And these are the topics that we're going to be talking about: maintenance of status, if your work location changes, the requirement to file a H-1B amendment, which companies H-1B dependent, what kind of LCAs you can expect in this area, and what is H-1B dependent, and how do we file petitions for H-1B dependent employers. Specialty occupation, what is a specialty occupation? What kind of RFEs? The specialty occupation RFEs are the most common RFEs that we receive. So this is extremely important to understand what is a specialty occupation, because that's the very basis on which a H1 is filed. Unless the position is a specialty occupation, you will not be able to file a H1. Numerical limitation is if someone is cap exempt, an employer is cap exempt, how are they cap exempt, on what basis? And if you say you're cap exempt, what RFEs you can expect, and what documentations to submit to avoid those kind of RFEs. Another very common RFE is an RFE for beneficiaries' qualifications, requesting for an evaluation to be done, especially if there's a foreign degree. Sometimes if you have a straightforward computer science degree, even though it's from India or some other country, we don't usually put an evaluation because USCIS kind of understands these degrees because so many of them have been filed in the past, and they know that they qualify as an equivalent of a US degree, but sometimes they don't. They don't understand the degree. They want to see an evaluation, sometimes of all foreign degrees. So in some years they send a lot of RFEs for foreign degree evaluation. So we get a lot of RFEs on that basis. So that's something we'll discuss. Number 6 is viable businesses. Usually, especially for consulting company type situations where you don't have an MSA or PO, or the person is working out of your office, and USCIS is not clear as to what they'll be working on or what kind of organization you have, or if you have a large enough organization to accommodate, to be able to pay the salary of that particular individual, then they'll send you an RFE on the viability of your business, whether you have an office space, whether what your tax returns look like, etc., etc. So let's get into each one. Next slide. The first one would be for maintenance of status. Now, this RFE will show you exactly what you shouldn't do in a change in work location. So this was a client who came to us after the RFE was the H1 was filed on their own, and they came to us and they got the RFE. And this is a learning moment as to what not to do, whether you're a beneficiary or whether you're an employer, what you shouldn't do. And you can see what happens. So in this particular case, just to give you some background, the petition was filed for this beneficiary in 2021. And when this petition was filed, the USCIS noticed that the LCA location was Alabama, but the pay stubs and the work location seemed to be North Carolina, because all the taxes were being filed from North Carolina. The pay stubs, his address was given as North Carolina in the I-129 petition. So they immediately sent an RFE in 2021, stating that it seems like you are not working at the location that you're supposed to be working at. This, I guess, in 2021 was an extension was filed at that time, or an amendment was filed, whatever it was. They said that you previously, you didn't seem like you were working where you're supposed to be working. So they sent a big RFE asking for W-2s, etc., etc. So what had happened at that time is that the employer basically did not notice that the address had changed. So the person was working from the correct address. He was working from Alabama, but the employer forgot to change that in their taxes. So they continued to pay taxes for North Carolina. They continued to use his North Carolina, which was his old address, while paying his taxes, etc., etc. Everything was North Carolina, even though physically he was located in Alabama. So this was more a tax violation. They didn't actually violate immigration law. So it was important to show that the physical location was Alabama as per the LCA, but it was just a tax violation, a tax problem. So unfortunately, the attorney at that time did not show that, did not highlight that, and therefore this case was denied. And the second mistake that the employer made was after the H1 was denied, the beneficiary continued working on his old H1 as if nothing had happened. So that was an issue as well. So that issue is also raised in this RFE. And then the third issue is when they filed this present case, what had happened is the person started working in Colorado, but they filed the petition after he moved to Colorado. They should have filed the petition before. So they brought that up also as an issue. So let's go through the RFE. It says your petition was filed with a subsequent request to extend the beneficiary's stay. To qualify for an extension, the beneficiary must show that they're maintaining status. And then they talk about how the previous petition was filed on May 5th, 2021. And they say on May 2022, you filed a petition with receipt number to amend the previously approved petition. And then in 2022, they sent an RFE. And then it states that, Birmingham, Alabama was provided as the LCA information, but the address was mentioned as North Carolina. And then it goes on to say that furthermore, the previously filed petition and the current address, you have provided a copy of the beneficiary's 2021 W-2 from your organization. This W-2 does not show any wages paid to the beneficiary for work performed in the state of Alabama. Instead, it shows that the organization only employed the beneficiary in the state of North Carolina. This is the last paragraph. So this is what they're saying is what I just explained. Next page. Furthermore, they say you've provided a copy of the beneficiary's 2022 W-2 forms, and even this has work performed in North Carolina, and you show that the 2022 forms also have work performed in Colorado. However, you never submitted a USCIS request requesting approval for beneficiary to work in North Carolina because the person was not actually working in North Carolina, he was working in Alabama. But the taxes all show that he's working in North Carolina, right? So they say that they denied the petition in 2022. They denied your request to extend the beneficiary status. You were informed that since you did not file a petition to reflect a change in beneficiary's employment, the beneficiary has not maintained their previously approved H1 status. And it says that at this time you are further informed that the decision may leave the beneficiary without any lawful status, etc., etc. So now at the time of the denial, the beneficiary was required to obtain a valid visa and leave the country and come back into the United States. So that's what they're saying, but they're saying that the records don't show that anybody has left. The record shows that the person is still in the US, so they want to know what's happening, on what basis they've been working since 2022. This is now 2024. Therefore, it appears the last paragraph, the beneficiary has not maintained their non-immigrant status as explained in detail above, right? This is all that they're saying. Next page. So now they're asking for all this information, detailed explanation regarding change in work location, copy of the approval to show that that new work location was actually approved by USCIS, any receipt numbers for the petitions that you might have filed asking for a change in work location, all your payroll documents, work schedules for the prior years, quarterly wage statement showing where the person worked, the federal tax returns, work product information, performance reviews, everything. They're asking for employment history records, copies of a valid visa to show that you left and re-entered the country. They're asking for all this information, and of course, they have nothing. Or even if they have any of the documents, it's not going to be in their favor because there was a mistake, and they did not. They just continued working on the previous H1 instead of leaving and coming back, after filing a new H1 and correcting all the mistakes. So based on all this, what we did was we tried to respond in the best way we could. We showed them that with reference to the address issue, that even though they say North Carolina in all the taxes, the person actually did work out of Alabama, and we showed proof of physical presence in Alabama. We showed his copy of his lease. We showed all his utility bills. We showed his credit card statements, his bank records to show that he actually was living in Alabama, right? So that's how we sought to take care of that issue. With reference to the fact that he never left the country after getting a denial, we said that he worked based on his previous H-1B petition because the previous H-1B petition was never revoked. So he did not actually have to leave the country. And we argued it that way, that he had previously an I-94 and he worked based on that. So at least there's no accruance of unlawful presence, which is important. There was an I-94, even though he's not maintained status technically because they never actually explained the fact that he worked physically in the correct location, so he didn't maintain status. But there's no unlawful presence because there's an I-94, so that was important to show them. And the third thing with reference to Colorado is we said that, yes, he did move before the USCIS petition was filed, but it was only 30 days since he moved. And that's how, and there is an exception with reference to the law that you can move within 30 days of, and then you can file an amendment 30 days later. Having said all that, they did send a denial. And though they accepted a few things that we have said, on the whole, the obviously the beneficiary did not maintain status, did not explain properly with reference to what had actually happened. And by the time we explained, it was too late. So they denied the entire petition, and now the beneficiary left the country and is hoping to refile. And we're hoping there's no unlawful presence issue here because there was an I-94 based on which he worked. Even though he shouldn't have, because after that he moved to different locations and he still worked on the previous, LCA petition. So that's how we dealt with it. And you can see the mess that it's created. And we were not able to correct the mess that happened 2 years ago. And, the person had to basically leave. So this is an example of what not to do. Yeah, H-1B dependent. Now, with reference to an employer, whether they are H-1B dependent or not, a person who is H-1B dependent is, this is how they define it. A H-1B dependent employer is defined as an employer that has 25 or fewer full-time employees, and 7 out of that are on H-1. So if you have less than 25 or less than that, 7 of them are on H-1, then you are H-1B dependent. If you have 26 or more full-time employees, then if more than 12 are on a H1, then you're dependent. If you have 51 or more full-time employees and at least 15% of them are on H1, then you are dependent. So if any of these apply to you, then you have to mention in your LCA specifically that you are H1B dependent, and you have to attest to the fact that you have followed some of the rules with reference to H-1B dependent employers. So there is a special tick mark that you have to do for H-1B dependent employers. Now, in this particular case, there was only one employee, and we said that the person was not H-1B dependent. But the USCIS is saying you have not established, this is the last paragraph, that you are not H-1B dependent employer. You indicated on your I-129 petition, page 19, that you're not H-1B dependent. Likewise, you indicated on page 6 on your LCA that you are not H-1B dependent. However, petitioner indicated on their I-129 petition that they have a total of 3 employees. USCIS records, however, indicates that the petitioner has filed five petitions within the last 1 year, of which 4 have been employed. So they're questioning whether you have 3 employees or you have more. So they're questioning how many employees you have, because they're saying that we have approved 5 petitions. So how is it that you have only 3 employees? So they are questioning the whole, 3 employees thing. They're thinking that maybe you have more. The reason this is important is because if an LCA is filed as a H-1B not dependent and you are dependent, then the entire H-1B can be denied, because you cannot then go back and file a new LCA, because there has to be an LCA that is filed as of the date of filing the H-1. So this is what they're trying to look for. They're always finding ways of denying the petition, and this is one way that they look into to see whether your case can be denied. So in order to avoid these kind of an RFEs, you should, preempt it by maybe submitting your payroll record to show how many employees you have as, supplementary evidence in a petition. Next slide. So they're asking for evidence to show that you either a new LCA if you are H-1B dependent, which is not possible to do, right? Because we can't go backdate an LCA unless we already have an LCA that maybe we filed for someone else. This would not have been an option. The only option is to show that we are not dependent, and these are a few documents that they're asking for. Statement that explains how many employees you've employed at the time that this petition was filed. So how many employees do you have? The 941 quarterly federal tax returns for the last 2 quarters just before you file this petition, and that will show the number of employees that you have. Quarterly wage reports for all the employees in all the states. This will also show how many employees you have. And then they want a table to show how many employees you have and how many of them are on H1, so that they can see whether you're dependent or not. So this is documentation that can be submitted ahead of time when you're filing your H-1B petition, especially sometimes when it's very close, the number of employees, and this can be for various reasons. It can be cap exempt reason, because you can't pass that 7 employees or that 25 employees, or it can be for the reasons of the filing fee. Though not discussed in this RFE, if you have less than 25 employees and you pay a certain filing fee, but say you have 24 employees, they'll definitely send a similar RFE asking for proof of the number of employees that you have. So you're better off submitting these kind of documents, quarterly federal tax returns, etc., to preempt that kind of an RFE, especially if the number of employees that you have is close to that number where you have to pay the additional fee. Next slide. So next, I want to talk about the numerical limitation RFE that we get. Now, this is if you're cap exempt, and I think we won't dwell on this too much because we're running out of time, and I want to give some time for questions as well. With reference to whether your employer is cap exempt, they can be cap exempt in many ways, and there's a list of the different ways that you can be cap exempt here. Can you zoom in a little bit?
Unfortunately, I won't be able to.
Okay. Okay. So hopefully you can read it, or if you need glasses like I do, please wear your glasses to read it. But yeah, so if you're an institution of higher education, oh, you actually did it.
Yeah,
but a little too much though. Maybe go back to the previous one. So if you're an institution of higher education, if you're a non-profit entity related or affiliated to an institution of higher education, if you're a research organization, you're a government research organization, or say you are a consulting company and the client actually qualifies as a cap exempt organization, as one of these above organizations, then also you can file your H-1B petition even after the cap is over. So there are various other, if you have accounted towards the cap before, or if you are on a J1, you could be cap exempt if you're a doctor on a J1 and you've received um, a J1 waiver. Also, if you're an employer subject to Guam Commonwealth, so if you're from there, then that could be also cap exempt. If you're subject to the Guam Commonwealth of North Marine Islands, CNMI. If you have a company there, then you could be cap exempt as well. So they're saying that you have filed for a cap exempt, and obviously the registrations are closed for this year, but we're not convinced that you're actually cap exempt. And in this case, it's a little complicated because this is a nurse case and a consulting company is filing for a nurse. So the end client is cap exempt because they are a hospital, but they are cap exempt because they are an higher education, an institution, a non-profit organization related to an institution of higher education. So they are a hospital and they are related to the University of North Carolina. So they are related to educational institution, a higher education institution. So it was a multi-prong RFE where we had to prove many things. Go to the next slide. So they're basically saying that you did not submit documentation regarding this issue. Please submit evidence to show that you qualify as a nonprofit entity related or affiliated with an institution of higher education. I'm reading the last paragraph. Evidence may include but is not related to the following. Next slide. So these are the documentary evidence that they're asking for. Documentation showing that you are connected to, associated with an institution of higher education. Usually there's a contract to show that, the hospital is connected to a college. But you also have to show that, so we did submit the contract, but they want to make sure that not only is there a relationship, but the beneficiary will be employed in a role which furthers that relationship. So if this hospital is a teaching hospital, then the beneficiary as a nurse should be teaching other nurses that are going to school, right? So they want to see a correlation there also. So there's a lot of information to be provided in this case. At the nexus between the job and the what the organization actually does, the contract between the hospital and the organization, uh, proof to show that it's a nonprofit organization. So a lot of documentation has to be submitted. So obviously, if this is a teaching moment, because you can see how much documentation has to be submitted for a cap exempt organization. So submitting this ahead of time will help avoid these kind of RFEs. Next slide. And also teaches you as to what documents is needed for these kind of RFEs, right? So they're saying that in order to show that it's cap exempt, look at the last few bulletin points. Detailed itinerary showing the number of hours the beneficiary will work at the organization, submit a letter from the organization that confirms the working hours. So they want to make sure that they're not going to be working at the consulting company, but the entire period of time they'll be working at this qualifying organization. Explanation and evidence regarding the nexus between the beneficiary's job and the essential mission, purpose, or objective of the qualifying organization, which is basically supporting the institution of higher education. Then contracts and work orders to show that there's a relationship between the hospital and the teaching institution. Evidence that the work location is, a non-profit, right? That's one of the. So then the the way to show that is, showing their tax exempt status. So a tax return should be sufficient. So this is some of the information needed in this situation. Next slide. Another kind of common RFE that we get is beneficiary qualifications. As I was mentioning earlier when we were talking about specialty occupation, when the person has a foreign degree, they want to either they want either a copy of the US degree, or if it's a foreign degree, they want the second bulletin point, hold a foreign degree determining to be equivalent to a US bachelor's degree required by specialty occupation from an accredited college or university. So they want an evaluation showing that the person has the equivalent of a US degree and that the degree is related to the job that they're going to be working in. Or they have a license, or if they don't have a degree that's related, then you can show that they have work experience. So go to the next slide. If they don't have a degree that's related, then perhaps you can show that the person has, work experience that is equivalent to the degree, right? So a work experience evaluation then can be submitted, and the work experience evaluation must show that the person has 3 years of work experience, which is equivalent to 1 year of degree. That's what it says here in this page. Next. And usually an evaluator will show that the 3 years of work experience is equivalent to 1 year of degree. You can go to the next page. Sometimes USCIS will also determine equivalency for you. If you don't want to go to an expert opinion letter, then you have to submit all the documentation, the 3 years of work experience. You have to show that the 3 years was progressive work experience. You have to show what degree you have, and you have to then have USCIS determine whether it's equivalent to a bachelor's degree in, say, computer science or not. Next slide. So this is a pretty common kind of RFE that we get. And in this kind of evaluation, if there is an expert opinion evaluation, if you read the last few bullet points, they're asking for the professor's qualifications, the person who's giving the evaluation, they're asking for their qualifications. So you have to submit their resume, you have to submit, if they are giving you an expert opinion letter on a work experience, then you have to submit a letter from the university stating that they qualify, and they do this for the university on a regular basis, meaning that they qualify their students' degrees and they for work experience. So if they do this on a regular basis for the college, then it should be fine if they're giving an expert opinion letter for USCIS. So you have to get that letter from the college saying that they do that on a regular basis for the college. And so we submit a detailed resume of the evaluator also showing how they're qualified to give this kind of evaluation. Usually if we're trying to evaluate a computer science degree, we get a professor in computer science. Next slide. This is the last slide. We have to show that the business is viable. Usually, if it's a consulting company or even otherwise, if you're not able to show that if you have not submitted documentation to show that why you're required to hire this person, so if you don't submit the MSAs, POs, and work orders, etc., then in that situation, usually they will ask for, this kind of this kind of an RFE where you have to submit proof that you are actually a viable business and you're doing sufficient work to show that you have a job for this person. So just quickly looking at these bulletin points, they're asking for the W-2s of all the employees. And when you're submitting these documents, you're not just submitting the documents blindly. You have to make sure that you vet the documents before submitting them, because if you're submitting W-2s and if they see in the W-2 that someone is on a H-1 and they're not being paid the prevailing wage, then that could lead to RFEs or denials on other cases, or a notice of intent to deny on a case that was already approved. So your tax returns, the organizational chart showing where the person will sit within the organization, a lease of the office. They want to know where the employee is going to work. So they want to know that you have a physical premises. They want to know what kind of a premises it is. Is it an office premises? Is it a workhouse? Is it a manufacturing premises? They want the floor plan. They want photographs of the office. They want utility bills to show that you're actually working at that office. So this is that all we have?
So yeah, on that note, we'll wrap up today's session. And once again, thank you so very much for attending this webinar.
Don't forget to subscribe to our videos if you like what you see. Also give us a thumbs up and share the video with your family and friends. Thank you.